So we've been looking at the tort of negligence, and within negligence the first thing you have to do is establish duty of care. And there are different ways to go about this. Sometimes you look at existing precedent, sometimes you use the occupier test, and sometimes there is other law dictating that a duty exists, such as the case with where you are an occupier of a premises within which a harm has occurred. Now, there's two acts which govern this kind of duty. You have the 1957 Occupiers Liability Act and the 1984 Occupiers Liability Act. The difference between the two is the later one deals with trespassers and the 1957 deals with lawful entrants. So we've been looking at the lawful visitors as per the 1957 Act, and we had a look at what is the general duty, then looking at specific cases of children and skilled workers, and then we had a look at some of the defences and warnings in these cases. And now we're going to look specifically at independent contractors, because they come up a lot in tort, because it's never sure where the liability falls with them. So when we're looking at occupiers liability, section 24B of the 1957 Act provides that it may be a defence to occupiers in some circumstances where the damages can be attributed to the work of independent contractors on their premises. And so we can see this in the case of Hazel and Dorr, 1941. The only obligation the landlord had was to take care that the lift was reasonably safe, and he had fulfilled that by employing a competent firm of engineers to make this happen, so he was not held liable. This can be compared, though, to Woodward and Mayer of Hastings, 1945, where the cleaner had a task of clearing the school steps from ice and snow, but a pupil was nevertheless injured. He slipped on the snow and ice. Now, this can be contrasted from Hazel, though, because it wasn't a technical task, and although it also had an element of independent contractors, the defendant could have and should have checked and realised that there was a danger, whereas with the lift this couldn't be the case, and so it was solely attributed to the independent contractors. Now, in ensuring that the contractors are competent, William and West Hertfordshire Hospital NHS Trust 2003 says that you might want to see whether they have adequate insurance. So in deciding the contractor's competence to do the job, the question was whether the contractor had insurance, or had insurance was relevant to the judgment in working out. Now, this has been called into question in Gloucester, and I think, let me find it, I think it was called Westmore Town Council 2009. Sorry about that, I forgot the defendant's name. Here, the defendant owed no duty to ensure the independent contractor had enough funds to pay for the damages. But I think the point still remains from William and Hertfordshire NHS Trust 2003 that when you're trying to, it's your duty to make sure that you bring in specialists. A factor you will look at is that if they're insured, but it doesn't matter so much as if they're insured to cover the damage that was in fact caused by the present case. I think that's the point that I'm trying to get across with these two cases. And then the last thing is, what is the standard of care where you're looking at actions of independent contractors? Well, Maguire and Sefton NBC 2006 says that in this case the defendant was entitled to consider that it had employed experts that had taken proper steps by entering into service contract so as to meet its duties under the 1957 Act. So once it's all passed, then you know that the duty no longer lies with the occupiers, but it lies with the independent contractors. I hope this helps. Thank you for watching.